My name is Harry, and I'm from London.
Meghan Markle here.
Today is February 11, 2023. It is 2:15 a.m. Today I was kind of lazy. Then I don't know, just pure lazy. I slept. I had enough sleep. Once I got up, I just didn't feel like recording. So I just hang out for like 2 hours just watching TV and at the same time scrolling through my phone, and I came across some tweets and I've already shared them on my community board, on my community board with you, and I said when I'm recording I'll share that with you. So I'm gonna have at least 3 videos today. One of them is I recorded yesterday. It was the second part of the video that I recorded, and then the first one went well. There was no issues, the sound was fine, everything. And then I went to do the second one. I didn't even bother looking at my screen that shows the recording device that's recording my screen. And it's afterward I've done the prayer and everything, and I saw the sound, the mic was off. I was so upset. I was really upset because usually once I go over a tweet, I give you my whatever it is that I'm thinking at the time. So all of that already gone. So I have to re-record them again, but it's gonna be later. But I have some new stuff to share with you. The first one is I'm gonna have at least 3 videos. The first one is gonna be very short. It's just 2 tweets, one regarding IPSO and regarding the lawsuit, and then that will be one video by itself. And then the second video will be new tweets that I came across, and then if I have energy and I feel like recording, I'll re-record whatever I did yesterday that did not record. Okay, so I see some of you really like these type of videos where I have music and do a short little clip that shows, you know, certain theme kind of thing. So I'm surprised 5,000 people have watched it. All right, so I love making this type of videos, but I feel like many of you are not on Twitter. These are more important. The information, the things that's going on to keep you informed are more important than these videos. Sometimes when I don't feel like doing any recording on Twitter or whatever, I'll make those videos, and this was one of them. And actually this is the long version. I had to do it twice because YouTube had give me some issues with some of the clips, and I had a comment under that video that says one of the music that I put was too loud. It's because the original Netflix video had a music in the background. So in order for me to capture Harry's voice and Meghan's voice, and at the same time try to eliminate the sound, the music that Netflix video had, I had to put a new a new sound to somewhat overlap, okay, overwrite the sound, the music and the background, and at the same time you'll be able to hear what Harry was saying. So I don't know, but anyway, I'm wasting time explaining things. And by the way, I'm on Spotify now. Okay, this is Spotify, similar to Twitter. I'm on Spotify. I changed the background to dark, you know. So okay, let's get going. Okay, this is my first tweet. If I need to change the background, I like the darker background. Okay, so this is my first tweet, and I will not be going over that article. I've shared that on my community board already, and the link will be in the description. I've also shared the link on my community board as well. Some of you have already read it. Okay, but I'm just gonna go over the tweets. Oh, it's not that much, so it should be quick. Okay, The Sun, Clarkson, Meghan, and IPSO prepare for another shaming episode of non-regulation. No matter how outraged you were by the vicious words used against the Duchess of Sussex, nothing will change, right at Brian Cathcart. Okay, so I came across IPSO a long time ago. I've mentioned to you, I've shared a lot of other tweets in response to IPSO, how I was able to come across them. It's because Harry, when newspapers were writing untruthful things and whatever that was pissing Harry off, and Harry had gone to IPSO and, you know, to make a complaint. Each time they do a review regarding some of Harry's complaint, they always say the newspapers were in the right, whatever, peripheral or the laws to write whatever it is that they wrote. So from that point on, Harry never go to IPSO anymore. Every time he has issues with a newspaper, he always take them to court once he knows it's something that he could win. Okay, so that's from that time I came across IPSO. So once I saw this article, and I forgot what I wrote on my community board regarding it. I think I said don't hold your breath or something like that. This one was kind of, there it is right here. This is what I said. Okay, I came across this article. I haven't read it yet. I thought I'd share it with you. I have a feeling the majority of people are leaning toward the same conclusion. Pretty much they're just gonna give it a pass. If they really punish newspaper or whoever wrote it, it will be a surprise to me and probably almost everybody else. Okay, that's that. So let's see some of the comment. We need labor to immediately revisit Levison 1 or 2. And I think the article, I skimmed through it a little bit. Okay, I skimmed through it. I think this also explained what IPSO is and the Levison inquiry. All right, so you need to read that article. It's very good. And Brian Cathcart is someone that I follow on Twitter. He's one of the, I think he's a professor and a professor of journalism. So there are some really good journalists in the UK who's doing what is supposed to be done when it comes to journalism. Okay, so I follow him on Twitter. All right, it will be more likely change if at BBC News gave it the profile and coverage it deserved, but the sad and simple fact is they are too focused on protecting their press mates. Yeah, like I've said before, they all are friends. Okay, I don't see how the system in the UK is gonna change. I really don't, because you still have the little people who don't have much, people who have to vote to allow these people to be in and all of that. They don't see the light. They don't see the light. So I don't see how the parameter, the system in the UK is gonna change anytime soon. If you look on my PYTE channel, there was the 2020 election. I was talking a lot about political stuff, and then a little bit after the US 2020 election, there was another election that was gonna happen in the UK, and I really swore that the UK was gonna vote the right way. Come to find out, not only they removed some of the good ones who were doing the work for the little people, they removed them and put more Tories in place. And I'm like, I was shocked. So I thought that was the thing here. So now on my next video, I hope I bookmarked it. There are people who's doing silent protests. They're not even screaming and yelling. They just hold the signs. Nope. What do? They go into, the police go into the crowd and grab whoever was holding the sign and arrest them. I think they arrest them or whatever. But during the time when Harry and Meghan were in the UK, the tabloid keeps on talking nonsense, repeatedly nonsense about Harry and Meghan. Meghan in particular, the Sussexes, non-stop. But I was looking into the political aspect of things. So I'm not surprised one bit one bit of what is happening now. I'm surprised they didn't act sooner than that, because they were putting laws in place or modify laws to prevent people to protest. Meanwhile, everybody was focused on Harry and Meghan. They were bashing them, and some of the little people were keeping quiet, then say a damn thing. Meanwhile, the tabloid is like a tag team. I told you guys, there's that recycle thing. What is it? The institution, the firm, put people in mental institution, make you go crazy, and then the government defund this stuff. Okay, turn a blind eye toward the institution, and then you have the tabloid masking or
You desired squirrel!
distract. It's like the squirrel kind of thing. Distract the people from seeing what the government is doing.
So that I may talk, squirrel.
So it's like a tag team. I do not see. I really don't. We're talking about it. People from outside talking about it. Some people in the UK are talking about it. But collectively, once they throw the racism into the UK, everybody forget about their problem. They don't care if they don't have heat. They don't care they can't eat. They don't care they don't have clean water. They don't care about anything. The racism just blind them. So I'm not surprised one bit. And now my only thing is, I don't know how they're gonna get over. The system in the UK is gonna change, because right now all the bodies are in the right place. They all are in the right post. It's like when you're playing baseball, there's bases. Okay, all of their team, their friends, their buddies are on the right bases to protect each other. So the UK, you're just running, and by the time you get to one of the bases, you're out. Okay, so that's it. Okay, let's go to the next one. Now this is the mother lode of all things, which I came across, and I've shared it on my community board already, and I saw it this earlier morning 2 a.m. or should I say 12 a.m. That's the time I posted on my community board, and you guys should have a heads up of that already. Okay, for all the people losing their minds over Samantha Markle demanding Meghan Markle be deposed, Samantha's lawyers did the paperwork all wrong. Denied. Okay, is there? Okay, I thought that was a link. If there was a link, I was gonna go in it. Okay, so there's this here: United States District Court, Middle District of Florida, Tampa Division, Samantha Markle, plaintiff, Meghan Markle, defendant. This cause came on for consideration upon the plaintiff's motion to compel defendants' responses to first request for production, first set of interrogatories, that's the depot, and first request for admission, Doc 60. Okay, document 60. In the present motion, the plaintiff Samantha Markle seeks to compel a multitude of discovery responses from the defendant Meghan, the Duchess of Sussex. However, the plaintiff motion does not comply, there's the part here, does not comply with the court's standing order regarding discovery motion. See Doc 3. I wish I had that. Okay, as the order explained, the parties must adhere to former local rule, so they then follow this rule, which set forth formatting requirements for motion to compel discovery. Further, the plaintiff providing the defendant's responses as exhibit is insufficient. Accordingly, the plaintiff motion will be denied without prejudice for a failure to comply with this court's order. So they then filed the thing correctly. Okay, there's this. It is therefore, upon consideration, ordered that the plaintiff's motion to compel defendants' responses to first request for production, first set of interrogatories, and first request for admissions, Doc 60, be the same is hereby denied without prejudice. Done in order at Tampa, Florida, 10th day of February, 2022. Oh. So when was that? 2022, February 22. So they make a mistake here. When was that? What date did they have? File February 10th, 23. So they make the wrong date here as well. Thomas G. Wilson, United States. All right, so dates is wrong here. I think they make a mistake here. The court make a mistake here. Okay, I literally cannot stop laughing. Have a wonderful weekend, everyone. There's that. Hi, what does this mean for Meghan? That means Meghan can be deposed to give a deposition. Samantha's lawyer didn't follow rules set by judge. Meghan's lawyer sent it back and it's denied. Okay, Meghan's lawyers sent it back and it denied. No, not Meghan. How do you call this? Samantha's. It denied. Her dream of grilling Meghan are up in smoke. Let's see here. Okay, thank you. Anytime. This is a date, 10 February 22. Is that an error? Okay, it's from today, but you are 100% correct. Great catch. The wrong date is listed at the end. Yeah, so they need to correct that. Okay, it's this is a fake judge. Is okay, this is fake. The judge is female, named Charles, not Thomas. Okay, I hate it without prejudice, but so glad it was denied. Okay, so what is okay? Let's see here. Okay, Thomas J. Wilson. No, it could be the people who's filing. The people. How do they call these people in the court? What is it? Could it be? I could be wrong. Okay, the clerks maybe who's looking into the filing before it even approached the judge. I think like a secretary kind of thing. Could it be that? Thomas J. Wilson, United States magistrate judge. Okay, what does that mean? That's not the trial judge, the magistrate judge. Okay, so I don't know. This could be fake, this could be, but there's this here case, this document 63, file 210. Okay, I don't know. Okay, I don't know if it's real or fake or whatever, but I'm just showing this. Okay, this is fake. The judge is female, named Charlie, not Thomas. Let's see here. There's 2 comments under it. Okay, this is a magistrate judge. In many cases, all discoveries, motion are handled by magistrate. That's what I was thinking. I'm thinking, well, I say secretary, but before it goes to the, I don't know. You know what? Let me keep my opinion out of this because I do not know how the court system literally work. All right, but I sort of have an idea what does that mean. Okay, I hate it without prejudice, but so glad it was denied. Okay, that's what happened when you use Groupons to source lawyers. Oh, is that where she got it? To God be the glory. Thank you, Jesus. I mean, with our prayers. But the thing is, though, the February 15th is still at play. It's just this part now where they're gonna be deposed, Meghan and all the listed people that they say, it's not there. Okay, it's not gonna be happening. They can't depose these people because she didn't file the proper thing. And I think when I was reading some of the forms where I think I said, I don't know if I kept it in the final recording when I was editing, I think I said it is up to what's her name, whoever, Samantha. Okay, she wants the information, so her lawyers have to set up the date to ask those particular questions to depose these people. It's not Meghan's job to do it. But what Meghan, if the judge has said, okay, you could do that, but Meghan's lawyer will have the same option as well to depose anybody that, Samantha will have in her team as well, to whatever. All right, so that's that. Let me leave it alone. Okay, so that's pretty much it. All right, so there's the squad coming out. No one cares. We do care because this is why we're sending our prayers for these people to leave Meghan alone, because these people don't give her a break. All right, deny without prejudice is ironic considering Samantha's extreme prejudice against Meghan. Appalling, this case is continuing. Meghan has a right of free speech just as Kimmy does. My weekend is made. Have a lovely night, y'all. All right, so that's that. Let's do a prayer.
Fight for my attention, for your ascension, you must prove. Cause if you can find it, you don't confine it, you let it move. Make way for the genie, scream for the dream may come true. Have you ever played with a queen?
So I've already did 2 videos. The last one that I'm supposed to redo again, I didn't do it yet, but I was just thinking about something. My first video I've done with it. I had 2 tweets, but after I finished it, the second video, I was thinking about something that I remember seeing when I was reading this tweet a while back, I think on the 8th, February 8th. So I went back to that tweet because there was a link that was shared in that. Where did I find the link? I think the article, that's it. The article link that was shared in that. And when I was reading this, which I did on video 1, which I'm gonna plug together at the beginning of this video, okay, there were some key things that were mentioned and I wanted to know what they are all about. So on February 8th, this article, I've shared it with you already. I think I read some part of it already. Yeah, I think I read it. But this, it reminds me of this. It seems like this is something lawyers, okay, who have access to this, so, or anybody maybe, because it's in that, on that website. So what I did here, I put the case number of where is it, this one, case number 8.22, whatever, this case number, into here. There it is here. Okay, so this is that, and hopefully I could see some of those keywords. I'm gonna check them out pretty much. Let me copy this so I don't have to type it over. Yes, I have it already. So let's go to that and see what's going on. If it's the same thing that I've already read, I'm not gonna read it again. Okay, when was this file? Okay, it looks like it's very long. Okay, so I read that already, I think. 6 pages. Let's go. It's very small, so it's gonna be hard for me to, I think the person, what they did here, they looked for the thing and kept it. So there's the case number as well here. Same thing. You guys could check, could go and check it yourself. So there's more. This looks different. But what page is that? Page 2. Same thing, I think it is. Oh, there's 7. Okay, I see. So one of 6 pages. Okay, let's see here. Okay, the plaintiff Samantha M. Markle, by and through her the undersigned counsel, hereby moved this court for an order to compelling defendant Meghan Markle to coordinate their position with the undersigned, and as grounds therefore states as follows: on January 3rd, 2023 at 10:11 a.m. the undersigned requests deposition. So, okay, I read that already. They wanted all these people. Samantha wanted Meghan to do deposition for all these people. By now, we already know this have been dismissed. Okay, I've shared that with you. And there was a mistake with the date. They put 2022 instead of 2023. I don't know if that plays a role into what's going on, so we shall see. Okay, so I've read that already. Mr. Comp, there's that. It's on the email, original email. Okay. Okay, plaintiff also indicate willingness to reschedule the depositions and the event. Yep, I read that already. It's on video 1, probably February 8th. So I want to see what else is there. Okay, page 6, I read that as well. So the squad put the important things, which I read already. So what is this now? The plaintiff Samantha Markle, by and through her undersigned counsel, hereby moved the court. Is it repeating the same thing? Okay, Duchess respond to all 3. Okay, so there's a little bit more information on this. Okay, so this might give a little more insight. Can this get bigger? Yes, it can. So we shall. Okay, this is the case. Plaintiff Samantha Markle and through undersigned. I think I read all of this. Let's see. Okay. Okay, production documents. Okay. And the Duchess responds to the first request for the production attached hereto and marks as Exhibit A. The Duchess asserted general objection which span from page 1 to 3, paragraph 1 through 9. So this is Meghan who object to what is being requested of her. Okay, so this is the part here. As of the date hereof, Meghan has not yet had a sufficient opportunity to discover or otherwise obtain and review all documents and materials which may have some bearing on this case. Consequently, these responses are based only upon such information and documents currently available, known to, or understood by Meghan. As this action proceeds, Meghan anticipates that further discovery, research, and analysis may supply additional facts and additional meaning to the known facts Meghan reserves her right to use as evidence in this action. Any hereafter acquired or discovered documents which will have been responsive to this request. Meghan objects to each request on the grounds that there is pending motion to dismiss the first amended complaint. Okay, this is exactly what I was aware of without even reading this. So Meghan doesn't want to do anything until the judge hear her objection to dismiss the case. This is what I get from that. Anyone who's in the law or know about this, you could correct me on this. And this is what I got on that. Okay, there's some code here, I don't know what it means. And pending motion to stay discovery, ECF number 54, Meghan objects to undertaking the burden of responding to expending discovery requests and collecting documents in light of the pending motion, which could result in the dismissal or stay. That's it. Yep, that's exactly that. Meghan wants to hear the judge, wants to get what the judge is saying regarding her objection to that, to dismiss the case. So she wants to wait until the judge say whether or not the case continue or dismiss or something like that of this action. Accordingly, while Meghan has provided the responses contained herein, she does not intend to produce responsive documents until the court has ruled on the pending motion to dismiss and motion to stay discovery. Emphasis added. Meghan objects to each request on the grounds that there is no protective order in place. Meghan does not intend to produce responsive documents until the parties stipulate to such an order and is entered by the magistrate. So the rules, there's something that needs to be done, they're not doing it. Like for instance, I think in one of the videos where it says, it probably within those documents, because the squad didn't take screenshot of all of it, probably said that there need to be, what's the term used? Not secret, private. Let's say she does the deposition. How is it gonna be sealed? That's the word. Is it gonna be sealed? Can anybody, because once you file something in court, anybody could ask the magistrate or whatever, go to the court, give the case number, and they make a print for you. You pay money, you got it. Okay, it's public record. So Meghan wants to make sure nobody can obtain that. That's the thing as well. And then Meghan also wants to make sure the judge hear her plea to dismiss the case before she does anything further. All right. Meghan objects to each request on the ground that there is no protective order in place. Meghan does not intend to produce responsive documents until, okay, she's saying here she's not gonna do any of this until, okay, the parties stipulate to such an order and it is entered by the magistrate. In other words, it needs to be recorded, make it legal, the judge hears it, and everybody understands the law. Okay. Meghan objects to each request of the extent that it seeks information which is protected from discovery by the attorney-client privilege, the attorney work product doctrine, or any other applicable privilege or doctrine. Meghan will not disclose any such protective information or documents in response to these requests. Any inadvertent disclosure of such information or documents shall not constitute a waiver of any privilege or of any other ground for objection to disclosure of the documents and or information, or of Meghan's right to object to the use of any such document and or information during these or any other proceedings. Meghan's responses are made solely for the purpose of this action. No incidental or implied admissions are intended by these responses. Meghan objects to each request to the extent it purports to impose any discovery obligation on her beyond the scope permitted by the federal rules of civil procedure and rules of court. In other words, it's not like Meghan is automatically dismissing it, like saying I'm not gonna do that. She wants to follow the law, and it's telling the court, with all due respect, I'm not gonna do this until you hear my plea to dismiss that. This kind of way. That's the way that I see it. Also, what Meghan is telling the court is that she wants to make sure whatever she disclosed within the court, she wants it to remain within the court. In other words, we assume that the tabloid wants to get those information to write their stories. Okay, so Meghan is telling the court, I want to make sure if I'm going to disclose this information, I wanted it to stay within the court and not go beyond the court kind of thing. So there's a way that she's letting the court know there's a possibility the intent of this to ask all this question is for something beyond what the lawsuit is. This is the idea that I'm getting. Then again, this is my opinion. I could be 100% wrong. Okay? That's what I'm getting from this. And the following responses, all definition and other instructions shall be treated as having no force or effect to the extent that they exceed those obligations. Each of the following responses and objections are based on Meghan's understanding of plaintiff's first set of requests for production. To the extent plaintiff is Meghan's half-sister, okay, Samantha. To the extent plaintiff asserts interpretation of any such request that is inconsistent with that of Meghan. I don't know if I understand this part correctly, but there's a sense that I'm getting here where Meghan sort of don't want her recollection, which might be different from her sister, to be held against her, because each one of them may have a different perspective of things. Because there's Meghan, who grew up as the only child of both Miss Doria and Thomas. So the sister may have a different perspective of that. So this is the sense that I'm getting, and Meghan doesn't want this in some shape or form. I don't know if I understand it correctly. They don't want this to have any weight if Meghan's perspective of things is different from her sister or something like that. That's the sense I'm getting, but then again, I could be 100% wrong. That's my opinion. Okay. Out of the 36 requests for production, the Duchess objects to each and every request and has failed to produce even one single document. So this part here, those paragraphs that I just read, this is what Meghan responded to. Now, from 7 and on, this is what I guess Samantha's lawyer is saying to the court here. Out of the 36 requests for production, the Duchess objected to each and every request and has failed to produce even one single document. And she explained why she's not gonna produce it. There's the rule of law that needs to be filed, and to make sure if she does it, the thing stays sealed. Not just anybody, someone like me who have nothing to do with the court case. Once I know the file number, I could go and ask for it. Okay, that's what she doesn't want anybody to just go and do it. And if I could do it, just imagine who else can do that. And also, she wants the court to hear her plea to dismiss the case, and she's gonna have to fight for it. Let the judge know why this case should be dismissed. Okay, so for example, request number 1 states any and all pictures which depict you and the plaintiff. What in the name? So this is what Samantha was asking for Meghan to explain what all of these pictures are. Like, for instance, when Meghan said she didn't see her for quite decades later, so Meghan should explain what these pictures are. When did she meet Meghan and all of that? What in the name? But anyway, let me read this. Okay, I was curious, so since I'm curious, I might as well share them with you. Okay, any and all pictures which depict you and the plaintiff. Response: Meghan incorporates her general objection as if set forth fully herein. Meghan further objects that this request seeks information that is not relevant to any party's claim or defense. So, in other words, let's say there's a picture of Meghan with her sister during during graduation or something. Okay, so she wants Meghan to explain, well, I don't know, what does the picture mean or something like that. So Meghan is saying, I'm not gonna respond to that. This has nothing to do with the case. Okay, so this is what I get from that. Okay, advent come, and to be relevant, a request for production must be reasonable connected to a claim or issue in the case. Okay, there's a case here. Another case that has happened that's similar to that. Okay, that's what that means. I think. Okay, let's see. Affirming district court denial of motion to compel responses on irrelevant and overboard request for production. The complaint control what discovery is relevant and proportional to this case. Okay, there's another case that's similar to what the sister's asking. Oh my God, this is a lot of research to see what was already done and to see how it matched yours. So that's what I get from this. You know how I understand this? Because I read Andrew's, the Andrew's case thing with Virginia Godfrey. And I did look into them. I'm crazy because I want to know. And here are the alleged statement at issue. Quote, a trust confidence shared. If there were more photographs of plaintiff and Meghan together, plaintiff will have sold them. Oh, okay, there's this. On its face refer to additional photographs and plaintiff possessions, not Meghan's. Okay, so in other words, Meghan does not have that picture. Okay, you know what I see in that as well because I follow the Johnny Depp thing. Here, this picture could have easily been photoshopped and then produced as if Meghan was there. I'm just saying, I'm not saying this is exactly what happened. I'm just giving an example, okay? It could have easily be a picture of the half-sister during graduation and then decided to pick a picture of Meghan and paste it there, make it seem like Meghan was there. So what I see here, what is being said here is that Meghan does not have that picture in her possession for her to give her opinion about it, because this could easily be altered. So they will have to get one of those people who does forensic to research. Where did it take? They could get coordinate. I'm telling you, this is what happened when I watched the Johnny Depp case. This is the thing that I got here. All right. So what Meghan is saying here, she doesn't have a possession of that picture, so she's not going to respond to it. Okay. It could have easily been sold. Where is it? A trust confidence shared, quote, if there were more photographs of plaintiff and Meghan, plaintiff is the half-sister, with Meghan together, plaintiff will have sold them. Okay, that's what it's saying. It probably sold it. Okay, there's a reference to whatever that is. Okay, on its face refer to additional photographs and plaintiff possession, not Meghan. So Meghan does not have a copy of that. So the sister, this is what it's saying here. The sister could have easily sold it. Okay, let's move on. Upon review, the Duchess' general objection, she specifically states that although, quote, Meghan has provided the responses contained herein, she does not intend to produce responsive documents until the court has ruled on the pending motion to dismiss and motion to stay discovery. Okay, we covered that already, where Meghan wants to make sure the court hear her plea, which is on February 15, whether to dismiss the case. Okay. In essence, the Duchess responded to the request for production as she was required to do so within 30 days under federal RCV. There's another section. This is like a rule, a law that Meghan's supposed to follow. So, in other words, what Meghan law is saying here, Meghan did respond to it. It responded to it and said, I'm not going to respond to it. Because I don't have a copy of the thing. You might probably sold it and it might be altered. She didn't say that, but I think based on my understanding. Okay, but with the intent to withhold the production of documents pending the motion to dismiss and motion to stay discovery. By doing so, the Duchess completely avoids searching for and producing the documents altogether. So yeah, so she said, I'm not going to even bother because my case needs to be heard too, whether it should be dismissed. Okay, that's what I get. Okay, under the federal RCV page 37, this is another rule, evasive or incomplete disclosure, answer or response must be treated as failure to disclose answer or response. Okay, the Duchess failed to make the diligent effort to provide a response that is fairly meet and complies with the discovery request, and 2, imposes no unnecessary burden or expense on the requesting party. Meadow District Discovery 2015. This is another case that's similar to that. They're giving an example. Keep in mind, as I'm reading this has already been rejected by the court. Okay, this is me who's being nosy, wanted to know what was said in the document, and I remember this was someplace. I'm gonna save that, so next time when there's something happen, I could, as long as I know the case, I could go into it and see what they put. Okay, this is public record. Okay, it is undisputed that the discovery deadline in the case management and scheduling order ECF number 49 as April 3rd 2023. Okay, and the Duchess may not improperly withhold producing document in the hopes that her motion may be granted. Okay, so this saying, I guess this is the court date where the trial is gonna happen. Okay, because Meghan's thing is in February. Okay, so they're saying that she may not have enough time to produce those documents, but Meghan is hoping that they dismiss the thing. Okay, request. Can you imagine this? Just think about it. The amount of headache they're putting her through. How is she able to do her own work, those charity work that she's doing? It's a lot of headache they're giving her to distract her from what she really wants to do. My God. And then when you look at on the docuseries on Netflix, when she was waiting to hear from her lawyer in the UK, where she was sitting by the chaise, and when she finally heard it, she break down. Okay, can you imagine all the time is that kind of mentality, the state that she's in? To hear this was, oh my God, it's a lot of burden. Just think about that. Okay, request number 5 states, and then to add to what I was saying is that if they deny all of this, it's best for the court to deny it now, because if Meghan goes to trial, remember, the longer it prolongs, the more you're paying your lawyers. And if at the end of all of that and Meghan win her case, okay, and then she's gonna have to pay Meghan, where she's gonna get that money? She needs to think about that as well, the sister. My goodness. Any and all phone logs which, what the hell? Request number 5 state phone logs. No wonder why the squad were talking about phone information. Okay, any and all phone. Nah, this has to come from the UK. They're requesting all of this because they're probably waiting for something bigger to happen. Oh my God. They want to know what she has. What in the name? This is the UK stuff here. They're making the sister to do the betting for her. This is my humble opinion on this. What this has to do with what's her name? The sister. Any and all phone logs which evidence calls between you and the authors of Finding Freedom. But then she just, on one of the documents, she said Meghan was the author. So there's inconsistency here. On that particular thing that I shared with you already, look on around February 8th, whatever I share with you, where it says that Meghan is the author of the Finding Freedom. So this is inconsistent. She needs to make up her mind. Okay, any and all phone logs which evidence calls between you and the authors of Finding Freedom. But remember the letter that I have where Meghan wanted to speak to Jason Kenoff regarding whatever was happening with at that time the name of the book did not happen yet, but it was making reference to Finding Freedom, but they mentioned Omid Scobie. Now the thing that I've said before here, remember Jason Kenoff was a backstabber, okay, due to the court hearing that was happening in the UK.
Have been, as we know, is that the Mail on Sunday had the ruling against them in February, and they were then appealing it. So it was lawyers from the Mail on Sunday who would have approached Jason Knaff, knowing that these emails and messages existed. That would have been the point, unless, I mean, the most likely outcome is that Jason obviously would have then gone to William and Kate, and clearly he has cooperated. He would not have cooperated with those lawyers without their definite knowledge.
Meghan could have easily told Jason to say certain things to Omid. Now, the brother of Harry could have easily tell Jason to switch her word for something else. So all of this needs to be understood, because why would, if Jason was doing things in good faith, why would Jason went? Okay, remember, it was perceived as if Jason was working with the Sussexes and with the Cambridges. But come to find out, he was not really working for the Sussexes, but instead for the Welleses, now the Welleses, or the Cambridges back then. And other royal voters were saying Jason Cunoff would have been taking order from William in order to do what he did in the UK trial.
You just explain, what was the significance on the witness statement from Ed Verity, better known as Ted Verity?
Ted Verity, the editor of the Mail on Sunday, said in his signed witness statement that he had been given information that helped support Associated's case. He said this information came from a senior palace source, and he said in his witness statement this was, quote, not gossip or tittle-tattle.
What does that mean?
What it means is that a senior figure in the royal household,
William and Kate,
according to Mail on Sunday, was passing him information in order to help defeat the Duchess's case.
So it could easily be switched as Jason Cunoff switched Meghan's wording, whatever was said to Omid. Now, if I was Meghan, I would say I will not provide that, because there was a third person, a middleman, and this is why Harry and Meghan say they're not talking to middle people. If they want to say something, they'll come out and say it with their full chest. This is the thing here, loss of translation and between. Remember, in one of my videos, I told you guys when I was in high school, one of my professors said, did an exercise in the classroom. He made all the kids line up in the classroom, and he said something to the one student, and then the student have to repeat it and to the next student, and it follows until the last student hear it, and then the last student have to say what he or she heard, okay, to see if it matches what was said originally. So things could be switched. We need to understand this part here, okay? So many obstacles could happen in between. So the phone call, Meghan, what is it? And Omid also said he didn't talk to Meghan.
The book seems to tell their story almost in their voices. Did they give their approval? Did they somehow weigh in?
I know there's a lot of speculation about the couple having sort of given secret interviews for the book and having weighed in, but it really couldn't be further from the truth.
Okay? There was none of this happen. Meghan did not have any conversation with Omid. And then we have the court document, the email, I think it is, where Meghan wrote to Jason Cunoff and tell Jason Cunoff, do you want to set a meeting to talk about her mother who was being harassed in the US and about Omid regarding whatever? So which means Omid probably gave Meghan a whole bunch of questions, and then Meghan's supposed to answer it and then give it to Jason Cunoff. And that's how the communication had happened. So there was no phone call. Omid had already said there was no conversation.
Did they give their approval? Did they somehow weigh in?
I know there's a lot of speculation about the couple having sort of given secret interviews for the book and having weighed in, but it really couldn't be further from the truth.
It was in court document in the UK, and then Omid have said it publicly. So what conversation here? But let's listen here. All right. So I've debunked this already. Any and all phone lags which evidence calls between you and the authors of Fighting Freedom. This is irrelevant to the case in my response. Response, Meghan incorporates her general objection as if it set forth fully herein. Meghan further objects that the term Royal Family Public Relations Team, there it is vague and ambiguous. Meghan further objects that this request assumes facts, namely that any such call occurred. Meghan further objects that this request violates her right to privacy. That's the thing here. Okay, so she shut this one down right there, and then there's a case that reflects to that, a case that happened in the US, Florida. Okay, there's that. Denying motion to compel production of invoices, statement or call lag. And then can you imagine that if Meghan respond to that and give it. Let's say if there was, and Meghan put it out there for everybody to hear, and there's communication between her and the royal family, and then that will give the royal family an excuse to sue Meghan. Okay? To say things, you know, the same way Meghan was able to sue for her privacy, and then that could be sued for privacy of the other person as well. Okay? Just think of it that way. Okay, invoices, statements, or call logs in view of plaintiff legitimate expectation of privacy and this type of records and the tenuous connection at best they might have to the issues in this lawsuit. There's another case similar to that, noting that discovery requests should be carefully scrutinized when they have the potential for harassment, embarrassment, and unnecessary invasion into one's private life. Meghan further objects that this request seeks documents and the exclusive possession, custody, and control of third parties. Okay? So in other words, the same thing. Those exact reason why Meghan won her case due to privacy, okay? They're setting Meghan. This is the thing here. They're setting Meghan for them to be able to sue her. That's the freaking thing that I'm seeing on this. Oh my God. By and through the Duchess responses, and I'm glad her lawyer sees that as well, and I think Meghan saw it too. Okay, by and through the Duchess responses, she continued in her pattern of incorporating the general objection and refusing to produce any documents to Mrs. Markle. Yeah, they're setting Meghan to failure and hope Meghan fall on the trap. And then, let's say if Meghan were to disclose some information there to the court, right? Now, people in the UK is gonna say, why did you invade my privacy to put out there? I don't know how they're gonna spend that. Okay, this is the leverage of things we need to understand here. And this is what they said, third party. Yeah, I didn't even finish with it and I saw this coming. Okay. To date, the Duchess has provided 0 documents to Mrs. Markle, and the Duchess appears to be delaying producing documents in the hope that this court may grant the motion to dismiss. I agree with her because this is very hard. She's going to intervene with a third party. Okay, to dismiss, there's the number ECF number 34. Can I copy this? No, I cannot. Okay, and or motion to stay, there's that. According to paragraph 2 of her responses to the first request for production, the case management and scheduling order provide a discovery deadline April 3rd, 2023, and Mrs. Markle only has a limited amount of time left to get discovery. For this reason, Mrs. Markle moves to compel the Duchess to respond to requests 1 through 36 of the first request for production. So in other words, she sees that time is coming. Oh my God, time is running out. So she wants her to respond right away. But there's February 15th coming, and Meghan is saying, I want the judge to hear why this should not be heard. Let me go on Google for a moment here. That's that. I'm here. Let's open another tab. What is this? This is that section here. Order deny motion for summary. Okay, the motion has been fully briefed and the court deemed it suitable for istifa. Plaintiff further allege. Okay, so that's a case to either for the thing to continue. Alright, so that's a section within the rule of law in Florida. Okay, interrogation. How many more do I have? Oh my God, I have 10 more pages. And the Duchess responds to the first request for interrogation. The Duchess asserted several preliminary responses and objection attached hereto and marked at Exhibit B, including, as of the date hereof, Meghan has not yet had a sufficient opportunity to discover or otherwise obtain and review all documents and materials which may have some bearing on this case. Consequently, these responses are based only upon such information and documents currently available, known to or understood by Meghan. As this action proceeds, Meghan anticipates that further discovery, research, and analysis may supply additional facts and additional meaning to the known fact. Meghan reserves her right to use as evident in this action any hereafter acquired or discovered documents which will have been responsive to this request. So in other words, Meghan wants more information. Why do you want all of this? This is what I'm getting from this. Okay, she asked 36 questions, and Meghan wants to know why you want all of this information, because there's other people involved. Do I want these people to get involved with your shenanigan? This kind of thing. Okay. Meghan objects to each request on the ground that there is a pending motion to dismiss the first amended complaint, that's this, and pending motion to stay discovery, that's that. Meghan objects to undertaking the burden of responding to expensive discovery requests and collecting documents in light of the pending motion, which could result in the dismissal or stay of this action. Accordingly, while Meghan has provided the responses contained herein, she does so without waiver of her motion to stay discovery. In other words, Meghan doesn't want to waste too much time to do all of this and then to have the thing dismissed. So she wants the court to hear her plea first, and hopefully they dismiss it. That's the whole process of this paragraph. Meghan objects to each request to the extent that it seeks information which is protected from discovery by the attorney-client privilege and attorney work product doctrine or any other application privilege or doctrine. Meghan will not disclose any such protected information or documents in response to these requests. Any inadvertent disclosure of such information or document shall not constitute a waiver of any privilege or of any other ground for objection to disclose of the documents and or information, or of Meghan's right to object to the use of any documents and or information during these or any other proceeding. I could see, for instance, Meghan going to, if let's say the thing continue, but we already know certain things have already been denied. Let's say, for instance, they said they want Meghan to do the disclose. Okay, example, she might have to go to court in the UK and ask the judge, can she release such information because of what's happening in the US, so she doesn't get sued in the UK for disclosing information. You see the boomerang of things, what nonsense her half-sister's putting her through? Can you imagine this? She's a baggage for God. Meghan's responses are made solely for the purpose of this action. No incidental or implied admission are intended by these responses. Meghan objects to each request to the extent it purports to impose any discovery obligation on her beyond the scope permitted by the federal rules of civil procedure and rules of court. In other words, Meghan doesn't want to go out of her way to please her sister for nonsense, shenanigan. She wants to stick with the whatever reason she called her for. Meghan wants to stick to that only. All the other questions she's asking about picture, to disclose this, to disclose that, no. Meghan said no. Not only do I want the judge to hear for it to be dismissed, I don't want to focus on shenanigan. This has nothing to do with what you're calling me to court for. That's the way I see that. Okay, and the following responses, all definition and other instructions shall be treated as having no force or effect to the extent that they exceed those obligations. Okay, out of the 23 interrogatory requests, the Duchess objects to each and every single one of the requests and either avoided answering the question altogether or provided either partial or full answer. It is impossible to know. For example, request number whatever it is, did you at any point discuss with anyone the idea of them participating or not participating in providing information to the author of Finding Freedom, or contact the author of Finding Freedom? If so, please explain when such discussion occur, where they occur, who was, oh my God, who was present, and what was said by whom, if it was verbal. You know what this was there? Do you know why this is there? So remember how I said how some of the UK royal rats are saying that Jason Kenoff must have asked William for to release, to go disclose to the tabloid?
Have been, as we know, is that the Mail on Sunday had the ruling against them in February, and they were then appealing it. So it was lawyers from the Mail on Sunday who would have approached Jason Naff, knowing that these emails and messages existed. That would have been the point, unless, I mean, the most likely outcome is that Jason obviously would have then gone to William and Kate, and clearly he has cooperated. He would not have cooperated with those lawyers without their definite knowledge.
To help the tabloid win the case. This is to clear William's name. Okay, to clear William, I think that's what it means. Okay, to say who was there when she was talking to that person. So William could say, I wasn't there, so don't blame me. This is what I see here. But the thing is that if you are the boss, you don't have to be there. You could have your henchman to go talk and then say, what did he say? And then you make him do what you want to do. Okay, this is the thing that I see. In my humble opinion. Okay, if it was in writing, including by text or email, or otherwise provide the date, the means of communication, they know the answer for that. This is in court document in the UK because I have that email. Okay, I have that email. And all who were directly privy, such as by CC to the communication. That's Jason Kanoff here. This is the part where Jason Kanoff thing here. Response, Meghan and Clarkson. So that was the question the sisters asking for her to say. But then again, what the hell this has to do with the sister? I don't understand. Why? But this is the response Meghan has for that question. Meghan incorporates her general objection as if set forth fully herein. Meghan further objects that this request contains at least 4 discrete subparts in violation of federal or okay, there's another law, whatever section here, City of Orlando. There's that thing, the related question test to determine whether the subpart of interrogatory or discrete, that is, this doesn't look good for the UK as well. If this goes to trial, they may seem like they're clearing their name in some shape or form, but it does not look good because Meghan could go and ask them question too. Okay, whether they subparts or logically or factually subsum within and necessarily related to the primary question. In other words, Meghan is saying that there's more to that. If I ask this person question, there's other people related to that question. It's not just yes or no, or this is the date, this is a that. There's more to it because we already know there's more people involved in that. Okay, with all of those video clip I keep on sharing with you, as we know, and then her lawyers were informed that there's a senior palace sources was telling this and that. Okay, we already know the answer to all of that. Okay, Meghan further objects that to the extent plaintiff is seeking to bolster her defamation claim by discovering evidence of some unknown wrongdoing, this is unwarranted fishing expedition. Yeah, that's exactly what I see. Cuomo versus Clearinghouse. This is another section, another court case that happened. I think that's what it is. You could look it up and see what it was all about. Finding that a request for discovery, which is wholly speculative and amounts simply to the request to conduct a fishing expedition, should be denied. Okay, Meghan is saying that they should deny this. It should not even be asked. Okay, here while the fact squarely identify 10 challenge statements, the request seek information about other communication with unknown individuals beside Jason Kanoff. Thank you. You see what just happened here? I was right. I was right because there's more people involved in this. Okay, squarely identify 10 challenge statement. The request seek information about other communication with unknown. This part, the unknown individuals beside Jason Kanoff.
What it means is that a senior figure in the royal household,
William and Kate,
according to Mail on Sunday, was passing him information in order to help defeat the Duchess's case.
Do you know why they could put Jason Kanoff here? Because it's in court document already in the UK. Okay, this is very well known. This is what I was saying at the beginning. Okay, let's see here. 7 more pages. Again, the Duchess reassert her general objection. Oh my God, I'm already 40 minutes, a lot of work. Objects to undertaking the burden of responding to expensive discovery requests. Like I was saying, even UK court might be involved in this. We already know the result of her lawsuit. We already know that. But to give this court, the US court, some of those information they are requesting, Samantha is requesting for, there might be a case in the UK to ask the judge, look, I am being sued in the US. I need to release some information. Can I give those information? So people in the UK don't come and sue her again. So it's like a continuing cycle. You see what I'm saying here? I'm not even a lawyer. I could see the ripple effect of all of this. And also, it does not look good for the UK, no matter which way you see it, because a lot of information will be disclosed. Object to undertaking the burden of responding to expensive discovery requests and collecting documents in light of the pending motion, which could result in the dismissal or stay of this action. Giving and cooperation. Meghan is saying all of the things she's asking is very expensive, and then there's no reason for me to go spend that much money to get those information when in fact I'm waiting for the judge to hear my plea to dismiss it. Okay, and there's a possibility it might be dismissed. Okay, giving the and cooperation of the Duchess' general objection to her response, it is unclear whether the Duchess has fully or partially responded to the request. Any claim by the Duchess that such interrogatory is a fishy expedition is no merit. Yeah, it is. Yeah, it is. You see, all those, this is what Meghan is responding to, and these are whatever Samantha's lawyer is responding back and saying, no, it's not a fishy, we just want to know. But what does it have to do with her case for defamation? Okay, there's that. Any claim by the Duchess, such interrogation, okay, no merit. The interrogatory is relevant to Miss Markle's claim and her amended complaint and the Duchess defenses under federal this and that. So they're giving their own section why it's relevant. Similar to the Duchess responses to the first request for production, she continues on a scheme of objecting. What scheme? The thing doesn't have any relevance. So she's just telling you there's no relevance for it. And then there's other subpart related to it. There's other people involved to her response. If she's gonna respond to it, there's other people's privacy, okay, that needs to be disclosed. But she can just go and give it to you and then to be sued by those people for releasing without their knowledge, without their permission. First request for production, she continues on a scheme of objecting to the interrogatory and avoid answering the questions propounded by Miss Markle altogether. Question number 4 states as follows. At any point in time, did you live with any of your sibling, half-sibling, or step-sibling? If so, please list name, oh my God, of the sibling, half-sibling. From what I understand, then Meghan's, even Miss Doria confirm it. By the time they were divorced, Meghan was what, young kid. Does Meghan even remember any of this? Does Meghan any remember of this? Because when you look at the video, her father was recording of them fishing. It was just her and the father. If one of them were in the background or we heard them in the video, then that could have been something different. Perhaps Meghan would have remembered at that age. Maybe she was 10 or something. But beyond that, my goodness. Okay, if so, please list names of the siblings, half-sibling, or step-sibling with which you live and the period of time which you lived together and the period of time you did not live together. Oh my God. Response. Meghan incorporate her general objection as if set forth fully herein. That was the question here, and this is Meghan's response, by the way. Okay, Meghan further object that this request seek information that is not relevant to any party's claim or defense. There's a section here. Amend, that's that. And as much as whether parties share residence before Meghan's living memory, there's the thing that I was saying. Does Meghan even remember? Okay, does not tend to establish the existence of a familiar relationship 35 years later. Oh my God, the Duchess incorporate. Okay, this is now her lawyers talking here, the half-sister. Okay, the Duchess incorporates her general objection, objects based on relevancy, and then Hollow avoid answering the interrogatory propounded. Giving the dilatory discovery tactic necessitate by the Duchess, she should be compelled to provide response to the 23 requests for answers to interrogatories propounded by Miss Markle. You can tell people, this is what I've said in another video. When it comes to the brain, it's very complex. You do not know what she remembers and what she doesn't remember. Okay. Admission. Mrs. Markle propounded a total of 38 requests for admission, the Duchess has objected to each and every one of the requests attached herein, Markle Exhibit C, as seen with the Duchess responses to the production and interrogatory request. She once again asserts a number of general objections, pages 1 to 3, okay, and incorporates those general objections into every single response. By doing so, the Duchess avoids answering any of the 38 requests for admission. As I'm reading this, okay, I just want to disclose this. I am not a lawyer. I'm not here to give advice of anything whatsoever. I'm reading what is public and then I'm inserting my opinion in that. Okay? So don't take any of the thing that I said as advice or what is exactly the law. Okay? I'm not qualified to give any of this. All right, let's continue reading. I'm on page 12. Oh my God, 5 more pages. For example, request number 1 states as follow. You are not an only child. So this is the part where, how do you call this? With the Oprah thing. But yeah, Meghan is the only child between, this is my opinion here, between Miss Doria and, how do you call this, and Thomas Markle. Yep, she is the only child between these two. So that's the answer for that. Okay, response. Meghan incorporates her general objection as if set forth fully herein. Meghan further objects that this request seek information that is not relevant to any party's claim or defense. There's a section here, amend, that's that. And as much as a statement that she grew up or did not grow up as an only child. Okay, there's that and quotation mark. Cannot be defamatory as a matter of law. Meghan further objects that this request is vague and ambiguous in as much as it does not distinguish between biological relationship on the one hand and the manner in which a child was raised on the other. Wow. Wow. And Meghan... But anyway, let's continue. I think most of the squad know the answer to that. The objections are without merit. The request is relevant to the plaintiff's amended complaint as well as the Duchess' defenses to this action and as proportional to the needs of the case. Moreover, the request is not vague or ambiguous. An only child, that's in quotation, is a person who never had a brother or sister. Only child, married. Okay, so they give the dictionary here. Well, when you ask the mother, Miss Doria, does Miss Doria have only other kids? So that's your answer to that. She spent more time with Miss Doria, only on weekend with the father. And then when she's there with the father, you guys were not there. The other half siblings were not there because they were old enough to move on their own. So, okay, let's see here. Dictionary, there's they give the page. Last visit, February 3rd, 2023. The request, the request asked whether the Duchess ever had a brother or sister. Miss Markle does not need to go so far as to specify between biological relations and the manner in which the child is raised. Okay, request number 3. Okay, you have a half-brother named Thomas Markle Jr. Response, Meghan incorporates her general objection as if set forth fully herein. Meghan further objects that this request seeks information that is not relevant to any party's claim or defense. There's a section here. Here, as much as a statement that she grew up or did not grow up as an only child cannot be defamatory as a matter of law. Meghan further objects that this request is vague and ambiguous here, and as much as it does not distinguish between biological relationship on the other hand and a familial relationship on the other. Okay, the objections asserted that the objection asserted by the Duchess are identical to request number 1 set forth. Upon review the Duchess' responses to the first request for admission, she asserted objection to every request and refuses to admit or deny even one of the 38 distinct requests for admission. As such, Mrs. Markle requests that the court compel the Duchess to my God, this is so stupid. Duchess to respond to requests 1 through 38 of the first request for admission. Conclusion. Whew, I'm almost done. Taking one by one, the Duchess' responses to the individual discovery requests are not all that troubling. Well, it is to her when she grew up by the only one, and then you never seen the your half sister, and all of a sudden this come bombarded at you. It is troubling. My goodness. However, given that the Duchess has failed to produce any document responsive to the first request for production, nor has she answered one single interrogatory, one single admission, or coordinated one deposition, it is clear that the Duchess is willfully withholding evidence and stonewalling discovery. Okay, she explained why she doesn't want to do it. Why she's not doing it, because there's more to that, and there's other things that is gonna invade in other people's privacy, and she had sued someone for going out of their way to disclose her privacy, so this thing can easily be done to be due to her. So she needs to take precaution, and she wants the court to hear in order for them to dismiss the case. Okay, she's not stonewalling it. She responded and tell you why. Okay, boilerplate or general objections are improper and constitute a waiver of the objections to the discovery sought. There's another section here. Okay, in general, responses to the discovery request, the Duchess object that certain questions are vague and ambiguous and are irrelevant to the instant action, but quote objections which state that discovery request is vague, overly broad, or unduly burdensome, or by themselves meaningless. Yes, it is burdensome, because she has to deal with the UK as well when to give those information that they're disclosing. And then there's a possibility they may have to ask William, knowing what we know now. William may have to be deposed, and she will have to go to the UK and ask the judge, can I disclose certain information? And then go to William and say, William, did you give information to the tabloid? Give the okay for Jason Kanoff to disclose some of my information. You think this is not going to go that far? My goodness. But objection, we state that a discovery request is vague, overly broad, or unduly burdensome, or by themselves meaningless, and are deemed without merit by this court. It may not be by this court, but it involves with the UK as well. Okay, so there's a whole bunch of section here. Under Federal Rule of Civil Procedure, there's this section here. Evasive or incomplete disclosure, answer, or response must be treated as a failure to disclose answer or response. Seascape, aquarium, this and that. There's another section. All of these are some other cases that had happened. Okay, the Duchess responses to the first request for interrogatories, first request for production, and first request for admission should be treated as a failure to answer. Wherefore, the plaintiff Samantha Markle respectfully requests that this court order that the defendant Meghan Markle be compelled to respond to the plaintiff first request for production, first request for answer to interrogatories, and first request for admissions, and such further and other relief as this court may deem just as proper. There's another law here. To undersign, contact counsel for defendant via telephone. Okay, this is the information of the lawyer. Oh my God, I read it all. Okay, so let's go back. And then we know, from my understanding, we know this was denied. Okay, right here. Okay, if this, okay, it is therefore upon consideration order that the plaintiff motion to compel defendant responses to first request for production, first set of interrogatories, and first request for admission, DAC 60, be and the same is hereby denied without prejudice. Okay, all of the stuff that I just read, this is it. The court responded and said it's denied. Meghan doesn't need to respond to all of that. Do you understand? Okay, so this is why I was very curious, because I remember, if I didn't remember seeing this and the what is it, how do they call this? There was a this particular article. I remember I was like, wait a second, I remember seeing this. I didn't read it in that particular video, but I remember seeing this, and I was like, oh, maybe if I put the case number in here, I could see what was asked. And there it is. Okay, these are all the things that just been denied. Okay, I was curious, and since I was curious, I was gonna read it all to myself, and I said, you know what? Oh, let me check if the mic is on. Yes, it is. I was gonna say I did all of this and the mic was off, but it was on. Okay, so since I was curious and I wanted to read it to myself, so I recorded and I'm gonna share it with you. All right, so that was the purpose of this, me with my curiosity, and I'm sharing that with you. All right, so that's it. The prayer that I did in the first part, at the end, I'm gonna answer it right now. Okay, that's it. Okay, this is one of the prayer. Oh, this thing is still what did I put here? Prayer for goodwill and goodwill for fellow human being, human being. Okay. Listen, prayer for thanks to the Lord. Let's do that. To the Lord. Let's see what pops up. I like to see if there is a small prayer. There's none. Abba is an inspirational speaker and coach. She travel. Okay, I'm looking for prayer. Oh, there's one here. A simple prayer of gratitude. Thank you, Lord, for the blessing you have bestowed on my life. You have provided me with more than I could ever have imagined. You have surrounded me with people who always look out for me. You have given me family and friends who bless me every day with kind words and action. This prayer remind me of this video that I have here. There's people, the family we will create or something like that, and I put some of the people who works with Harry and Meghan and all of that. So that prayer just remind me of that video. All right, so where is the prayer? Let's pick another prayer. I'm thinking of this prayer of gratitude and giving thanks to God. Oh Lord, thank you for the peace that passes all understanding, so we can be calm in the midst of our storms. Thank you for the daily protection. Thank you for bringing purpose and new meaning into our lives. Serving you, Lord, is never a task but a fulfillment. It feels so good to serve you, our Master, for without you, we are nothing. In Jesus' name I pray, amen. All right, so this is it. Thank you for, please take a moment to subscribe, like, and share. If you want to support this channel, there's a PayPal link and a Cash App link in the description. You could donate. Those who have donated, thank you. All right, so that's it. Now let me put these two parts together.
Have been, as we know, is that the Mail on Sunday had the ruling against them in February, and they were then appealing it. So it was lawyers from the Mail on Sunday who would have approached Jason Naff, knowing that these emails and messages existed. That would have been the point. Unless, I mean, the most likely outcome is that Jason obviously would have then gone to William and Kate, and clearly he has cooperated. He would not have cooperated with those lawyers without their definite knowledge.